NYU law professor Melissa Murray has a new book out, The U.S. Constitution, a Comprehensive and Annotated Guide. And we started our conversation asking about those comments from the Chief Justice, both what he said and why he felt he had to say it.
It's interesting that the Chief Justice felt compelled to say this. I think there's been a lot of attention on the court over the last couple of years, not simply because this particular court with its conservative supermajority has overruled a major decision in almost all of the last 5 years, but because the court has been the increased subject of media commentary and coverage. The New York Times has deployed a Pulitzer Prize-winning investigative journalist on the court's beat. And, very recently, Jodi Kantor, that journalist, and Adam Liptak, a stalwart of the Supreme Court beat, recently produced a story that showed that the Chief Justice has actually been the architect of what has emerged as a major shift in the court's procedures, and that's the use of the shadow docket. And, for the Chief Justice to say that they are improperly viewed as political is kind of rich, given the nature of that story, which showed the Chief Justice really pushing the court to depart from traditional procedures about the shadow docket's use in order to kill an Obama administration EPA plan. So, I think it's a little bit weak sauce for the Chief Justice, but I understand it.
Can you explain to people who may not be familiar what you mean by shadow docket, how it's been used in the past and how it's being used now?
Sure. The shadow docket is an interim procedural docket that's used for case management. It's typically been used in the context of the death penalty or election law disputes where you have to have an interim or decision in the middle of pending litigation because the litigation is time sensitive for some reason. So, for example, in the context of the death penalty, someone will be executed in a few days and therefore a decision is needed. It typically wasn't used for real substantive questions, but just before the Trump administration, in the waning days of the Obama administration, there began to be more activity on the shadow docket, with states taking cases directly to the court from pending litigation on the shadow docket and actually getting substantive rulings. The critique of the shadow docket, though, is that it's not an ideal place to do that kind of substantive decision making because often those issues are not subject to full briefing and oral argument, and the court often issues very spare rulings, sometimes just a line or a single paragraph, nothing more, and you don't get a lot of reasoning, so it's not entirely transparent. There's been a huge uptick in the number of times the administration, both the Trump administration and the states and state governments, have gone to the court seeking shadow docket rulings on substantive questions. And one of the things this reporting in the New York Times turned up was that in cases where a Republican administration is doing something and wants to continue doing it, the court is often very amenable in their shadow docket rulings to those administration requests.
I want to ask you about that Voting Rights Act case. I mentioned that decision from last week. And I'm curious sort of what it means in a practical sense. So we've seen the evisceration of it over several cases now. What does it mean on a practical basis as we look at this war of redistricting playing out in many states across the country?
So, David, you're exactly right that the Voting Rights Act has been under siege for some time. This began in 2013 with Shelby County versus Holder, which eviscerated the pre-clearance regime that required states with a history of suppressive voting laws and practices to first clear any changes in their voting laws with the Department of Justice or a three-judge court. In the wake of that decision in 2013, states rushed to implement new laws and procedures around voting, including more restrictive laws regarding voter ID. This new challenge to Section 2 of the Voting Rights Act really hobbles what was left of the Voting Rights Act in terms of a means of keeping states from promulgating more suppressive voting laws. It has made it a lot harder for redistricting to happen in a way that maximizes or optimizes the potential of minority groups to elect candidates of their choice. And more importantly, the court was a little craven in how it decided this. Justice Alito did not say he was eliminating or ending Section 2. Instead, he said he was preserving its central tenets. And what that means is while Section 2 will no longer be used to challenge racial gerrymanders that disadvantage voters of color, it still stands and likely will be able to be used to challenge redistricting efforts in blue states that try to optimize the voting strength of those constituents.
Well, we've got you. I also want to ask you about tariffs. So we had this ruling that struck down the IEEPA tariffs, but in response to that, President Trump imposed a 10% tariff on imports, which the Court of International Trade knocked down. Where does this go now? And does the administration have a legal pathway to try to keep those tariffs in place or reimpose them?
Well, the administration, in the wake of the Supreme Court's tariffs rulings, turned to another statutory provision, Section 122,
Right.
to promulgate this new set of tariffs. And it was under Section 22 that this new court, the Court of International Trade, determined that that was also an improper use of that statutory provision. So this will be appealed to an intermediate appellate court. It likely will go on to the Supreme Court. What was especially interesting about the lower court ruling that we got yesterday was that, in addition to invalidating the tariffs under that statutory provision, it also said that the administration had to refund the money collected. That was not something the Supreme Court did in its tariffs rulings that we had earlier this year. That's a real blow to the administration that will surely be challenged, and this likely will continue on through the federal courts.
Before we get to the book, let me ask you lastly about this Lisa Cook case. We're still waiting on that decision, and I think we detected some skepticism among the justices as the government argued that President Trump should be able to fire a Federal Reserve governor. Your sense of what's likely to happen with that decision and the import of it, yes, of course, of acute interest to a lot of Bloomberg viewers and listeners who care a lot about the Federal Reserve, but more broadly speaking, about the integrity of these historically independent institutions in the U.S. government.
So the Lisa Cook case is one of a series of cases attacking the independence of administrative agencies, and in particular, the independence of those agencies in terms of the commissioners or members that sit on their boards. Typically, Congress, which creates these bodies, will insulate those members from presidential removal, saying that the president can only remove the individual for cause or under very limited circumstances. There's another case pending, Trump versus Slaughter, which is about the removal of a commissioner of the FTC. I think that will likely be one that the administration prevails on, and it will result likely in the overturning of a very longstanding precedent from the 1930s, Humphrey's executor, which said that Congress could dictate terms under which presidents were limited in their ability to remove officers of those kinds of multi-member commissions. The case of Lisa Cook is slightly different. It is about removal, certainly, but the president has insisted that he has cause to remove Lisa Cook. So there's a different kind of procedural valence here. But as we saw in the oral argument in that case, the court was really skeptical, and it has been incredibly skeptical of any kind of assault on the administrative state that would implicate the Federal Reserve as well. They've always said that the Fed is different. The logic of that statement is really weak and wobbly. It's not quite clear how the Federal Reserve is different from other multi-member bipartisan commissions. Other than that, the Federal Reserve has direct implications for the justices' retirement portfolios. But we are getting a sense that the economy matters. It matters to this court. The stability of the economy matters. And for that reason, the Fed and Lisa Cook may be somewhat insulated from presidential whims.
Let's talk about your most recent book here. So some carry a pocket constitution. Were I to carry this in my pocket, I would have to get it tailored to be a bit bigger. You have the Constitution there.
Cargo pants. Yes. I can see cargo pants in David's future.
The Constitution is there, but there's a lot of history. There's commentary from you as well. Who is the audience for this book? This is a moment when we're looking ahead to the nation's 250th birthday. A lot of emphasis on what's constitutional and not. It's a phrase we hear a lot. Who do you hope reads this book, and what do you hope that they get out of it?
My hope is the same hope that the framers of the Constitution had. They wrote a document intending for the American public to read it, to understand it, to grapple with it, to debate it. And we've lost that in a lot of ways. Not only do we not engage with the Constitution on a regular basis, we don't even teach our children how to engage with this text. We don't have civics education in most schools going forward. And my goal here was to try and fill that void. This is not a book for law professors. It's not necessarily a book for lawyers, although lawyers are certainly welcome to read it. It is a book for ordinary Americans who are looking around right now, seeing ICE detentions in the streets, seeing the prospect of military patrols at polling stations, and asking, can they do that? Is that what our government wants to do? And can they actually do it? And I think this book provides a lot of the history around what the framers were trying to do, their insistence that the government should be one that could operate efficiently, but not be so powerful that it overran the people and trampled on their rights, becoming tyrannical. They were trying to strike a balance. And I think this book invites every American to consider whether in this moment we are striking the balance that they contemplated.